This is Global Order. I'm Hindol Sengupta. I invited my friend Nikhil Mehra to talk about one critical thing today. Nikhil is a lawyer, a well known lawyer in the Indian Supreme Court. There's been a lot of talk about communal issues and communal violence in India. And I wanted Nikhil to give a perspective to one key thing in 2012, 2013, and a little while before that, there used to be this idea that India should have an anti communal violence bill. Now, this anti communal violence bill, as far as its basic idea is concerned, seemed perfectly kosher. It was going to fight and stop communal violence, which is violence between different communities, including Hindus and Muslims and others in India. Now, behind that kosher idea, of course, it was very, very problematic. Now, this idea has been floating around for a long time. It's being brought up once again in different shapes and forms. And this was absolutely the right moment, according to me, to talk to somebody like Nikhil to understand why this was so problematic and why it remains a no go, or should be at least remain a no go zone as far as policy making is in India, policy making happens in India. Nikhil, thanks for your time.
Thank you for having me, Hindol. Pleasure to be here.
Nikhil, to begin with, the anti-communal violence bill, like I said, on the face of it, sounds like a perfectly reasonable idea. India has a long history of violence. It has seen partition, which saw Hindus, Muslims, and Sikhs fight out with each other. 1 million people died. All of this, makes sense to have some sort of legal framework to try and prevent communities from fighting with each other in India. However, this particular bill was highly problematic. Take us through why the framework was very problematic.
See, Hindol, there are social reasons why these riots happen, right? The biggest problem in India is we seem to think we can fill the gap of society somehow with a legislation. It never happens, right? Legislation.
Very good point.
If you want to have legislations that are going to have effect, you need to have substantial infrastructure behind them. By the way, this particular legislation attempted that as well. Let's leave the definitions of this aside for a second. Let's just examine what would happen in a communal riot prior to even this suggestion. And the short answer is that all communal riots would be prosecuted under the general criminal law. And the rules that would apply are rules of common intention, section 30 of the old CRPC. I'm not going to go into the new laws as of now because conceptually that will be complicated for people. But broadly speaking, without going into section numbers, that used to be common intention, common intent, common intention, and common purpose, right? So a mob has a common intention with each other. You may be in the back of the line and not actually executing anything, but you have a common intention with those who are perpetrating the criminal act. And that is the provision under which multitudes of people used to get prosecuted. Many used to get out because they would somehow or the other find an escape route within the law and not be prosecuted. Now, the truth is this comes out in 2011. It's floated first in 2011. The first point of illegality of this bill is that it originates from the erstwhile NAC, National Accountability Commission. Now, what was this? This was an extra constitutional body set up by the UPA, effectively above the cabinet, which is quite shocking, being led by a person who we all in that time regard as the de facto prime minister, which is Sonia Gandhi, but certainly not the de jure prime minister. She had no responsibility as a prime minister. She never took oath as prime minister. And so this was the classical modern Congress model of the Gandhis get all the powers, but none of the responsibility. This is also the time where that bad habit got ingrained into even Rahul. Rahul would not take any position within the government. Absolutely none. But the power that they would wield was disproportionate to any kind of responsibility that they actually had in reality, on paper, right? So the NAC first comes up with a bill. Now, the precursor to this bill was a 2005 bill that dealt actually with rehabilitation post-communal violence. And that was a limited purpose, right? The theory behind this particular bill was, and before I go into the structure, is that when communal violence occurs in India, and let's be crystal clear, communal violence in India is almost exclusively, when we're talking religious violence, we're not talking about sectarian violence, but religious violence, almost exclusively Hindu-Muslim, right? So you look at, but both sides have very different truths, right? So you look at 2002, the Muslims will say, we were suddenly attacked and attacked en masse, and we had very little to defend with, and we died disproportionately large numbers. Hindus will say, please look at the history of the 90s, right? This kind of anger emerges because of one incident, certainly at the Godhra station, where 159 car sevaks were burnt alive within the train, and then your subsequent attempts at falsifying even that fact. But leave that aside, they will say that through the 90s, please look at the number of criminal gangs in Gujarat that operated, that were entirely Muslim operated, and the oppression that they had created, and the political patronage of the Congress that had existed for those gangs. And so once the Congress loses power on the footing that the BJP comes in saying, we will clean these up, it never actually re-emerges, right? So now two sides are very different truths. And this is important to bear in mind to the structure of the act. One side says there is a longitudinal violence problem from the minority, right, which affects our rights on a day-to-day basis. And the other says there's a disproportionately high violence in that sharpened 4-5 day riot phase. Now, what does the law go and do? The law says your Hindu truth will not be given any weight right now, because that is a longer law and order problem that will be dealt with separately. But that one piquant problem of the disproportionate impact on the minority during the course of the riots, that will be dealt by a legislation. So what is this legislation proposed to do? Just bear in mind that there are certain things that I want to sort of contextualize, because this is sort of extremely sharp politics by the Congress at that point in time. Let's not presume that this is some great forward-looking venture by the Congress. This was really sharp politics, and the amount of criticism this bill got right from the inception, from all quarters, even from within their quarters, meant it just never saw day of light. There was never a question of it being passed into law. It was a draft bill circulated. Rajya Sabha even had a debate. The debate lasted for a brief moment where the law minister was asked, are you going to table it? He said, not right now. End of story. Right? But in civil society, it was ravaged. This bill was utterly ravaged by every commenter, including Supreme Court judges sitting and passed. In 2004 and 5, you'll remember the famous Manmohan Singh statement that minorities have the first right to resources. He then attempted also a religious census of the army, communalize the army, right? Now, please bear in mind that there are political purposes to these. These are not the well-meaning actions of this. They appear to be on the face of it. The political action is this. Post-84, Congress realizes because of the Ram Janmabhoomi movement, they have essentially lost the Hindu vote. It has got splintered quite sharply into the Samajwadi parties, right, into the Bahujan parties. And that means that now they need to find some way to offset that, because the way they look at it is that at 18-20% Muslim vote, they can always go and get. Now they need to add 10, 12, 15% here. So the idea was to somehow introduce Muslim reservation into OBC reservation, right? And to create this larger scope for Muslim votes, and you guarantee yourself that 20%. Then you come out with certain freebies, etc., whatever you need to, and go get your extra 8-10%, and that's enough in coalition era. You're going to be 180, 190 seats. You'll always be in power. That was sort of the perception. And perhaps you can even go higher at some point in time. I mention this only because these are the charges that are called as appeasement politics, right? There are a lot of others. There are a lot of other things that happen simultaneously. With one stroke of the pen, Kapil Sibal, as HRD minister, effectively recognizes 9,000 odd institutions as minority institutions, while applying the RTE Act, while imposing the RTE Act, implying that anybody who's a minority institution does not have to come within the ambit of the RTE and its onerous obligations. Implying that, therefore, any school which does not recognize itself as a minority, therefore a Hindu-owned school, would have to comply with these provisions. And therefore, there is arbitrage, right? It's more expensive for you to run a school. It's more difficult for you to run a school. Your smaller schools are going to fail. Even your schools in poverty-stricken spaces had to shut down because you could not meet up to these requirements of the Act, right? So in this entire sort of atmosphere comes the next big thing. And the next big thing was sort of surprising because yes, the 2002 Gujarat riot happened. But let's be crystal clear that something as heinous as 2611 had happened in 2008 and there was no riot. This is also the era in which there was a multiple set of terror attacks. I mean, we are talking about an era from 2005 onwards, Hindol, if memory serves you right as well. We were looking at terror attacks every few months. There used to be a bomb blast in some market or the other, Ahmedabad, Delhi, everywhere, Bombay, this is periodically happening, Gujarat multiple times. And no riot happened. That's the thing that I want to point out, right? And yet this act was introduced. So the idea of this act, the basic truth it wishes to recognize, right, is that there is a disproportionate impact on minorities in a riot. That's the first fundamental truth that it wants to establish. Perhaps this is true, perhaps this is false, but there's not enough data that was even presented on that score. And let's say that that is true. That is really perhaps true only in terms of the loss of property, etc. And you could have come up with various schemes for rehabilitation for that. But let's be crystal clear: rehabilitation at that time, because the Indian state was weaker, it was not as rich, was not a strong suit of the Indian state in any event. I mean, Kashmiri Pandits spent decades languishing in those same camps. They're still in those same camps in Jammu, for example, in parts of Delhi, still in those same camps. That rehabilitation, only certain state governments took on a war footing and made it happen, right? So that would be one element to it. But the legal element that really aroused suspicion this time around was they created an arbitrage into the manner in which the same action would be looked at if you were a majority perpetrator versus if you were a minority perpetrator, right? And so to that end, I'm just going to read a couple of definitions from the Act, right? So ostensibly, this is the Prevention of Communal and Targeted Violence, Access to Justice and Reparations Act 2011.
Yes.
And I want to first come to a definition of group, which you will find in section 3, subclause E. Group means a religious or linguistic minority in any state in the Union of India or scheduled castes or scheduled tribes within the meaning of clause 24 and 25 of Article 366 of the Constitution of India. So immediately you have created a disparity in that definition.
So I want to come in here, Nikhil, essentially, and this is important for people to understand. If you use this definition in an anti-communal violence act or bill, proposed law, you are essentially saying that in no way can the majority community in India ever be a victim of targeted violence
So that I think stretches a little too far for two reasons. All right.
Okay.
One is the majority community can be a victim, but it cannot avail the provisions of this act. It will have to file its complaints against under the general criminal law, right? Which is a unfairness because the stringency of the rules under this act would have been far sharper. So let's say you're in a communal violence situation. There is a minority person with a weapon in their hand who is attacking a majority person who also has a weapon in their hand, and they're both going at it. Every blow rained down by the minority member will only invite censure under the general criminal law, whereas every blow rained down by the majority member will invite censure under this special law.
That's a bit farcical. It's the same right, it's the same violence.
This is why I wanted to put it that way, that literally we are doing exactly the same thing in that moment in time. Our intentions are the same. We act in that manner, right? But you get the benefit of general criminal law and perhaps better bail provision. I get the stringency of this special law where bail would have been near impossible. They literally lifted the bail provision from Makoka, from the Maharashtra Crime Syndicate Act, and placed it here, right? So bail became a very difficult thing. And this is the era in which a number of legislation were passed where bail just became more and more difficult, and that we're bearing the fruits of that now, because now you see that in even economic legislation in India. Supreme Court upheld this once in the context of quota. It has since then become an albatross around our neck, because every law they will suddenly come and say, oh, this is one of the worst ills in Indian society, therefore the bail should be extremely stringent. Madness. Anyway, be that as it may, that the definition, as you correctly pointed out, it did create that dichotomy, right? And so a group could only be a minority, but a group would also include a scheduled caste or a scheduled tribe. So essentially, it is a bill, and the Congress must have realized at some point in time that you're actually attacking the OBC. Because when riots happen, it's rarely the Brahmin who's out on the streets who's doing the attacking. It's perhaps the OBC. And it's the OBC that you have omitted from the definition of group. And so, and then OBC attacks, you literally be looking at, so just imagine the madness of this. You are trying to ostensibly introduce a legislative measure to remove identitarian violence by targeting identity first and foremost of both the victim and the perpetrator.
This is particularly interesting because essentially, and we are bearing the fruits, as you say, of all of this and all these ideas that have been put into the system, even if they haven't become law. Because essentially, like you're saying, I mean, the smaller communities within the majority, like the Brahmins, they are anyway such a small community. Their numbers will not reflect very heavily. It is the other communities within the larger majority, the OBCs and others, who will bear or who would have borne the brunt of such legislation.
Right.
Because in the same case of violence, in the same region, in the same locality, doing the same things, they would be treated differently as far as the law is concerned.
That's the point I wanted to get across, right? Same event, same set of actions, two separate legislative regimes. Right? That's the disparity that somehow you can't sort of get over this disparity, right? So that's what this definition of group does. There are also offenses relating to creation of a hostile environment against a group. A hostile environment against a group means an intimidating or coercive environment that is created when a person belonging to any group or defined under this act by virtue of his or her membership of that group is subjected to any of the following acts, which is boycott of trade or business of such person, or making it otherwise difficult for him or her to earn a living, or public humiliation of such person, or to deprive or threaten to deprive such person of his or her fundamental rights, or force each person to leave his or her own home or place of ordinary residence, or any other act. Now, again, a litany of bad ideas, because these are really undefined kind of act. What does it mean to say that I am depriving you of your fundamental right? I don't quite understand this, right? I could be saying something about you, right? The effect of that may be that it affects your right to trade. Is that going to imply that either I don't have the right to speak up about you because of your identity, whereas you can speak up about me about my identity, right? And if I do, then I go into jail for creating a hostile environment, right? Now, the interesting thing was the reason why they started to fall. See, this is what happens when people who are completely disconnected with the ground make laws that are extremely adventurous. Why am I put it that way? Extremely adventurous law. The number one set of cases that they found of economic boycott of each other was between Dalits and Muslims. This Jai Bhim, Jai Meme rubbish that they keep coming up with, it never works. Why does it not work? Because nobody fights each other on the ground as much as these two. And pork is a big problem in that issue, because SCSTs do consume pork and Muslims can't tolerate that. So there are a number of yatras of SCST gurus always face violence from Muslim gurus. Right? So therefore, you have no practical understanding of what these societies are, what the realities between them are, and you've created this law which would create effectively in a riot that was, say, between a Muslim and a SC/ST, the law wouldn't apply. Right? But let's say within that riot, an OBC or a Brahmin came up and said, look, I support what you're doing because I understand your rights, and you are standing up for your rights. You can be booked under this act. And this is a fundamental tenet of the law. All persons are equal before the law, particularly in the context of criminal law. Because if you start creating arbitrage in criminal law, you are essentially creating a disparity on the evenness of the law. Right? Structural problems of how the law applies to different communities can't be solved through legislative means. Those are solved through actual hard alteration of infrastructure, of your reportage of reform within police, that was never undertaken by anyone, right? So this legislation also had various provisions that related to command responsibility concepts from international law. Command responsibility concepts.
Let's come to command responsibility in just a second, Nikhil, but I want to tackle one more thing. Wanted to ask you one more thing. There's another provision in this law which seems very strange to me, which is that essentially state governments and elected state governments and chief ministers, in a sense, could be dismissed by a body that this law would create, which in fact members of this body
I
de
was going to
facto could
come to
never
that.
be fired.
I wanted to define the offenses first and
Okay.
then come to the structure that the infrastructure.
All
that they
right.
were
Okay.
back in.
Fine. So let's go to the command issue
Right.
then.
So now you're saying that for dereliction, for any particular civil servant or politician in the hierarchy who makes any statement whatsoever, they will, if that statement is relatable to the actions that have occurred on the ground, you get arrested. You are punished for it. So really, again, because you create the disparity, what you do is that one side can speak as they wish to, the other side cannot.
And also the command issue, and correct me if I'm wrong, means that for every offense at an executive level, you are able to take the blame right up to the highest authority in the chain of command.
That's right. That's right. So the BJP had come out with a booklet on this at that time to critique it, to call it like, I believe that, I mean, it's in true BJP tradition, it's not the sharpest thing. But there is a portion by Arun Jaitley which really is worth reading. But it's called The Communal Face of the Congress Exposed. NAC's Prevention of Communal and Targeted Violence Bill. The bit by Arun Jaitley is certainly worth a read, but it cuts across the board. You can see group after group after group is completely opposed to this bill. Christians were opposed to this bill. Christians basically were saying, look, you don't understand that there are places where violence occurs against us and not from the majority community. And in fact, sometimes our protection comes from the majority community. So you're not really understanding the anatomy of violence in India, or anatomy of a riot in India. But let's not labor too much on this. What it also created, right? And this was the thing that you were coming to. It established a, just a moment. Yeah, I just wanted to come to the definition of victim as well, because this is correlated, right? A victim means any person belonging to a group. So a group has to be a minority. A victim can only be a minority.
But this actually, I mean, let me say this as a historian. If you look at the history of riots in India, this completely flies in the face of evidence that we know from the history of riots in India. It is not true in India that only one community is always the perpetrator and the other is the victim. It's just not correct. Historically, there is no such evidence.
It's not. It's not. It's absolutely not. This was the issue with it. This is why the framing of it was wrong. This is why, for example, I think both of us had shared this particular quote by Jawaharlal Nehru, where he was talking about how his reality is the Muslim numbers are such that they never have a reason to be violent or attack, absent attack or violence by Hindus. So the presumption is the fault is first the Hindus. And that Nehruvian presumption underlies the understanding of exactly this NAC as well. But let's go to something that you had pointed to, right? The NAC.
It's interesting. Can we just hold for a moment, Nikhil, on this point? This quote by Nehru, right? In a sense, these are all. I mean, when we're looking at, and as we go forward in this conversation, I'll also ask you if there are any parallels to this kind of legislation anywhere in the world. But this Nehruvian presumption, as you correctly call it, imagine that. I mean, that already flew in the face of Nehru's own experience, surely, during the riots of partition, but has completely flown in the face of demographics as it evolved from 1947 to 2011, when this bill is first presented. So essentially, we are going by just the thought of a man which has no bearing on the evidence on the ground, not only when he was alive, but 50, 60 years afterwards.
This is why in my opening I set out the ground for what the politics of the Congress at that time was. This is not a a factual truth which is being legislated. It's a politics that's being legislated. A certain kind of politics, right? So again, these are same trends. You set up an NAC. What is an NAC? NAC is an unaccountable body of essentially NGO, the power brokers within the government, who are all NGO operators essentially, headed by Sonia Gandhi. This is where the NGOification of the Congress has become complete nearly. And they are proposing bills, they are proposing policies. Cabinet comes and rubber stamps them because how dare they not? This has already come from Sonia ji. And then those get passed into law thereafter, right? And so you have bypassed a decision-making structure. You have essentially taken a body as important as the cabinet and reposed what is supposed to be a decision to be made only by them into a body that has no presence in the law. And you do the same thing here. And I want to show what happens here. This particular bill advocated for the creation of a national authority for communal harmony, justice, and reparation. The central government shall constitute a body known as the National Authority for Communal Harmony, Justice, and Reparation to exercise the powers and perform the functions assigned to it under this Act. This authority shall be a body corporate with the same aforesaid blah, blah, blah. Now, there were certain requirements of a membership. It would have 4 members. 1 member should belong to the SC/ST community. 4 women, whether chairperson, vice chairperson, or member. And there shall be a secretary general who shall be the officer of the rank of secretary to the government of India. Essentially, you start taking people from civil society who are beholden to you and putting them into these bodies, and they get to be the arbiters of truth, right? On any particular riot, their reports, their assessment of the truth is what will stand.
The incredible part is how can, even if you look at it completely objectively as one should, how is it possible that this body, this bunch of people from civil society and some political parties, they have no, I mean, they are not on the ground where the violence happens. They don't have any way of evaluating in a manner. The police might be, might have its own sort of prejudices. Essentially, you're bypassing any objective measure on what actually happened in that riot. It is basically the opinion of a bunch of people.
Now, the difference is now, we'll go to the powers. It may be more than an opinion. It may be more insidious than that. Don't be surprised by this structure. This structure also exists in the NHRC, right? But the NHRC is a recommendatory body. NHRC by itself doesn't have any powers. The National Commission for Women, similar. They have certain powers after which they become functus officio. Once they are not able to solve a problem within their confines, at most they can register an FIR. But look at what these guys can do. I want to show these powers. The national authority shall inquire or investigate suo motu upon any information or otherwise received in relation to the occurrence or likely occurrence of offences of communal and targeted violence, negligence to the prevention of communal and targeted violence by public servants, receive and collect information on any acts that indicate a build-up by state or non-state actors of offences under this Act, entertain appeals against the decisions of the State Assessment Committee in relation to non-inclusion of names of persons, blah, blah. This is in relation to defining a victim. Issue advisories and make recommendations, frame in consultation with the central government schemes for relief, frame in consultation with the central government guidelines in relation to prevention and control of communal and targeted violence. But most importantly, the power to suo motu investigate, right, would have perhaps, now that was the function. Now, the powers of national authority would have perhaps required the creation of a separate police body, or a police body that would be beholden to them. Now, please understand something. Under Indian constitutional structure, law and order is the state subject, right? So, play this along with the 356. Let's say a small event occurs in a Gujarat, which is under the BJP, while the Congress is in power at the center. A larger event occurs, say, in an ally state of the Congress in Bihar or in Bengal. They ignore the one in Bihar or Bengal, and they say, look, no, this looks like a local law and order problem, which the state is effectively handled, but yours is a communal problem.
And it also says, Nikhil, correct me if I'm wrong, it says not only incidents that have occurred, but also incidents that are likely to occur.
That's right. That's right. That's right. right? These are powers given to police officers on the ground in relation to very particularized situations in their jurisdiction to which they have a reasonable apprehension. Right? Now, look at the powers. National authority, in the fulfillment of its objectives, shall have the following powers: requisitioning information from the central government and state government or non-state actors. So, therefore, now Atista Setalwad's testimony becomes official record. And the official version of the truth of the event, or at least one official version of the truth that occurred on the ground.
Because you mentioned Tista Setalvad here.
I mention her only
No,
as a
and
marker.
yeah,
Right?
yeah, as a
It could
marker.
be anybody. Take Rana Ayub. It could be Rana Ayub.
Yeah,
Or
yeah.
take anybody from the right wing side, the RSS version of the
No,
truth.
I think I must mention this story here, which is why this bill has always stayed in my mind. I used to be a reporter, a TV reporter in those days, and I was sitting outside the office of a very prominent minister in the government. This was, I think, in 2013, right before the elections, or 2014, right before the elections, and Tista Setalvad was on the phone with this person who I will not name. And even though the minister was saying many of the things that you were saying, that, there is objections and this, that, and the other, we're trying and this, that, Tista Setalvad kept on insisting in that phone call that no matter what happens, the one thing that the government must do before there is an election is get this bill passed. This is the most important agenda. So, that incident has remained in my mind as a bit of an illustrative incident.
Yeah, yeah. Look, what is it? Yeah, look at the randomness of the powers of this body. Let me read through a couple more powers. It's very important. Sorry, 1 second. Yeah. Issue directions to state authorities in relation to conduct of any inquiry. Boss, I'm telling you today, the Supreme Court cannot issue directions to an investigating officer on the manner in which they are conducting an inquiry. A magistrate cannot issue directions to a police officer on the manner in which they are conducting an inquiry. Otherwise, the separation of powers between the executive and the judiciary gets breached. You can monitor an investigation. You cannot say ask this question or pursue this line of inquiry. But these are given that power. Effectively, you become a police officer, but with certain magisterial control, because you are also a fact-finding body who is going to release reports. Now, on top of that, appointing any person to observe, gather facts and information, inquire on its behalf. You could set up a completely parallel investigative system. Right? So the powers of the state government get ousted by another body, which is essentially a non-governmental body, with certain governmental members, no doubt, set up legislatively, but non-governmental body, to inquire into these kinds of events.
And we are not even very clear, correct me if I'm wrong, whether the members of this body were time-bound or, could they be replaced?
There are durations of office, there are powers for removal, but renewals keep happening. Look, you create a new power center is what it was. You have to go at the BJP in its critique was talking about how what you get to do now is to pick and choose who you want to prosecute, when you want to prosecute, for whatever the flimsy ground that you may find. Right? But you don't actually get to address, this legislation doesn't actually address root causes of communal violence. So let's be clear. 2002, there's a major riot in Gujarat, right? The only other riot that's happened, the proper communal riot that's happened in India after that was I'm not going to count the one in Delhi in 2020 because those really were an eruption that occurred because at one time you sat in Shaheen Bagh, you were allowed to sit in Shaheen Bagh. You tactically moved from there to create a fight somewhere or the other. Within 2 days, that was suppressed and ended. Right? But Muzaffarnagar happened in 2013.
Yeah.
And Muzaffarnagar is extremely illustrative of why this law would have been such a bad law.
Yes, talk to us about why.
Muzaffarnagar occurs when the Jat community sets up a Maha Panchayat, right, of the Western UP Jats, saying, what was the topic of that? It was called Maha Panchayat Beti Bahu Izzat Bachao. They say for 2.5 years under the SP government of that time, for longer periods than that, in fact, even maybe from 2008-9 onwards, when they came to power, FIRs against Muslim men abducting or otherwise assaulting, and these assaults, these sexual assaults go from minor sexual assaults to major sexual assaults to rape to disappearances, was simply not being registered in police stations across Western. This keeps going on and on and on and on. And in 2013, then this panchayat happens, and the story what we got was after this panchayat occurred, tractors and trailers full of these people coming back, Jats were coming back, and some of these were accosted by Muslim communities. They were butchered and they were thrown into canals, and these bodies were visible in the canals. And that's when the Jats united and went to war effectively. Otherwise, these used to be communities. You see, in a Western UP village, I don't know how well versed you are, but you must be because you're a journalist. See, I had a lot of family in Western UP, so I've seen this up close, right? There will be two families that are Tyagis. They'll be living next to each other. One will be a Mullah Tyagi, the other will be a OBC Tyagi.
That's right. Yeah.
Jat Tyagi, right? So they're exactly the same. It's just that there is a difference in religion that's created. Community-wise, culture-wise, very, very similar. They used to live in harmony in that sense, right? But because you start creating this imbalance of power for one community over the other, the behavior of one community changes, that aggression on the ground starts. Now, what do you say? It's exactly the same principle as I was highlighting in the context of Gujarat. Hindus are turning around and saying, in so-called peacetime, you don't pursue criminal complaints when you need to, right? And we react because we have no option left because the state has betrayed us altogether. And now you're going to impose a fresh law upon us, which is much worse than what we can do upon that. And it appears that this particular reaction by the Jats was so severe, Hindol, that we are seeing a substantial movement of Muslim settlements within the hill areas which never used to exist earlier. We're seeing it in Uttarakhand, we're seeing it in Himachal, etc. Right? And it appears that some of it is displacement from these regions after that riot. Right? So what happens is perhaps the bill is correct that in certain circumstances the disproportionate impact post-riot occurs. Right? Because now there is no sense of security of going back and taking over your own old home and coming back to your own land. And Muslims are the ones who get ejected the most. Right? That is why, for example, Kerala suddenly goes from a 30%, 35% Muslim population, rises to 60, 65, 70% in a period of a decade. Anywhere else, this would be called genocide. If this was a city that had suddenly become Hindu populated at that rapid rate, it would be called a genocide of Muslims. So these things happen. It's not an entirely disputable fact, but these are elements to be cured through infrastructure, through the structure of your policing, through your reform in your police. You don't need a separate legislative mechanism which creates effect. The provisions of this act are not dissimilar to a UAPA, are not dissimilar to a Gunda Act, right? So they're a completely different beast altogether. And you set up a separate body which effectively ousts the states and can hold the states themselves responsible. Now, this is what? See, today, 2002 happened. One of the great themes of the Congress government at that time while in power, post that time, after they've been ejected from power, was that Narendra Modi was not diligent enough. At the very least, if he was not directly responsible or directing itself the violence, he was at least not diligent enough. He abdicated his duties, for which he was thoroughly investigated by the CBI. Case could not be made up. Right? You acted through the CBI, you ejected a sitting home minister of a state from that. Amit Shah was ejected from Gujarat and he had to go live in Bihar for a few years until he won his cases and came back. Right? So it's not as if you didn't have powers. You had all of the powers. You're just not able to execute. What you want to be able to create is a mechanism that bypasses otherwise what would be investigative procedures and set up basically your version of the truth in every single scenario.
Yeah. Well, it goes back to the point that we were making about the Nehruvian assumption, Nikhil.
And most importantly, weaponize it.
Yeah. Yeah, it goes back to the same point that we were making about the Nehruvian assumption. It basically flows from that assumption, right? I mean, you're working on the basis of that assumption. It doesn't matter what are the institutions on the ground, what really happened, and what really happened is often complex. All of that doesn't matter. Demographic change over 60 years doesn't matter. You are just focused on what you believe in, and you will create whatever institutions that will enable that truth, so to speak, to be established. As we come towards the end of this conversation, I have one big thing to ask you. There are conflicts like this around the world, including in the developed world, increasingly in the last 10, 15 years after 9/11. Is there any parallel? And I think this is what it's important for people to understand. Has there ever been, or is there a parallel of such a law, such a body trying to be established, trying to enforce these kind of, extrajudicial rules almost? Is there any parallel to such an attempt?
Hindol, forget about this piece of legislation. There is no parallel to the way we conduct our constitutionalism. I mean, the wokes are sitting there saying there should be identitarian-based differentiation of rights in the United States. We've mastered this. We've already done this. Like no one else has ever done it before. We've already done it. Perhaps only Lebanon comes close, which has really consociated to a mind-boggling degree to the point where their society and their economy is literally a non-existent thing now, right? But yes, what you will have in Europe, for example, are certain tried and tested truths. So, for example, anti will be very strong, right? But that's a very different reality. I would put that at parallel to having the SC/ST Atrocities Act in India.
Yeah.
Right?
Yeah, because Semitism has a history
That's right.
in Europe,
That's
right?
That's
I mean,
right.
after all, we cannot, we can't wash up the fact that the Holocaust happened. I mean, it's a different reality. Yeah.
There you go. There you go. But even there, at least in the United States, the fact that you can deny the Holocaust happened is a protected right. Right? Maybe not in Germany, you can't do that anymore. But it's a protected right, right? But what you don't have anywhere in the world is this kind of mechanism where an actual act of violence takes place. And the act of violence of one person is treated to be of a greater severity than that of the other purely based on identity. In fact, the same act is amenable to a higher punishment based on identity.
I mean, Nikhil, in your opinion, in your long history as a Supreme Court lawyer, do you think in recent years, at least in the last 25 years, let's say, right? Would you think this actually happened even before the word woke came into being in the West. Would you think this was India's most almost blatant, woke politics, the bringing about of this bill?
This is not even woke. I don't think even the wokes have the sense that there has to be a complete disparity of this nature. I mean, perhaps some of the mad
Much
ones.
worse.
This is worse. Look, this is why it never took off. It just never went anywhere.
Yeah.
It couldn't even reach the floor of parliament. It couldn't survive national level scrutiny. The Congress was not willing to pitch itself behind it. And even today, they don't talk of this. They don't talk of it anymore. They want to keep away from, they've been singed by this one. So,
that it was even created, that it, went as far as for a bill to be created, an attempt to be made, this should be remembered.
Absolutely, it should be remembered. And the reason why I brought it up was when Rahul Gandhi made that statement on the floor of parliament in response to the president's address, right? It harked back to this because his statement was, and I take it at face value, that he was referring to the BJP. I'm not even going to create the controversy, although his words were, Hindu kabhi hinsak nahi ho sakta, right? A Hindu can never be violent. In essence, what he's doing is creating a litmus test that this creates. If you are violent, you can't be Hindu, you must be a BJP or RSS Sanghi, and you will be dealt with in this manner. That's what he was saying, that you have to be stopped at all costs. So it comes from this exact mentality that whatever be the situation, you have no right to any attack, whatever be the situation on the ground, right? But the truth is this. We understand how these things change. They change with greater urbanization, they change with greater wealth, they change with greater education, they change with higher standards of living, with a superior economy. And therefore, riots in India are becoming a rarity. The reaction from both sides is becoming much more of a rarity. Let me give you an example.
Oh.
In my opinion, post Nupur Sharma's events, right? Let's take Nupur Sharma's case. Right? Nupur Sharma, for what she said, could have been prosecuted under this bill, under its hate speech provisions. But the men who cut off the throat of Kanhaiya Lal and Kishori Lal, who beheaded them in anger because those people had the temerity to even share or comment on Nupur Sharma's statement, they could not have been prosecuted under this act. This is the madness that
That is just madness. That's madness.
That's right, right?
And let's not forget, in the Nupur, the Nupur Sharma case is being, buried in a sense, but 6 people have been killed.
That's right.
For the sake of one thing. They didn't even say what Nupur Sharma said. They only one person literally liked some post.
That's right.
And that was not even a post which was saying that what Nupur Sharma was saying. It was only saying we support Nupur Sharma or something like that.
Yeah.
And that man only liked that and his throat was cut.
Yes. So what I'm trying to drive at is even that is a act of grave provocation, because that's a purely religious issue. You are actually attacking religion, right? You're showing the capacity to go to war in the name of religion, and that did not have the reaction of a riot. Right? Even in Bangalore recently, when it was actually a congressman's son who had made a statement on Facebook in a similar kind of angry argument, and had made some comment about the Prophet. Muslim community had come out at night and had protested big time, but no riot broke. Right? That tendency is reducing. The only exception I will leave to you, because today, to me, news-wise, it is essentially a black hole, is Bengal. I don't understand how Bengal keeps getting away with the events that are occurring over there, both judicially as well as from the lens of the center. But that's a different matter. I'm not going to comment beyond a point, because what I commented on public forums is more than enough. But this is what I'm trying to drive at, that essentially you had a mechanism evolved to create this disparity. That politics is not dead. That politics, to me, was heard from Rahul Gandhi's own mouth in Parliament on that day. It's in the nature of the same politics. And there are other unfinished legislative agendas they'll keep bringing back. 99 seats suddenly seems like 299 to them. So they're feeling very confident. And these sort of fights will re-emerge again. It's very interesting to me that his latest comments seem to suggest that Hindutva politics is done, it is over, it is dead. Right? But the way he is behaving, it might give more of an argument for Hindutva politics to revive and to reform its aims and goals.
A lot of people are watching all these things, right? I mean, the public reacts in very different ways. I mean, I hear that, for instance, in Ayodhya, for instance, a lot of people think something went drastically wrong and, a correction should be done in voting and so on and so forth. But be that as it may, in elections, may the best man win. My point is that, there are 2 big things that are the takeaways, I think, in our conversation today, Nikhil, from what you've explained and detailed. Number one, in a sense, there is an unbroken ideological thought that's going on. From the Nehruvian quote to the coming of this bill, right up to what was said in Parliament recently. That idea has never died down, and that's what we should be worried about. We should be worried even more, because this has, as you point out as a senior Supreme Court lawyer, there is no parallel to this kind of ideological legislation being created and pushed as propaganda anywhere in the world. And in this few places, or one place that there's maybe some parallels there, Lebanon. I mean, surely Lebanon cannot be anybody's example.
Yeah. So the politics is essential. But I think the more important, the other element is this kind of legislation today, if it were promoted, it stands defeated by the fact that change of social factors is actually not necessitated this anymore. Things are better. Things are just simply better. Yeah, there's a lot of noise. In fact, I quite support the noise. I think free speech is very important in these circumstances. Let people say what they have to say. Let all of it come out. It's much better than to have it all pent up and then finding new avenues and new routes for it to sort of emerge. But that generally happens through the route of violence. Better to let people speak. The state capacity increases, you can even protect people more for speaking. And all sides will have to accept that they will be heavily criticized. That's what happens in a multi-ethnic, multi-religious country. Yeah. But what you cannot have is an arbitrage created within the law based on identity, in criminal law in particular. You're not handing out a benefit of state largesse where the state in its wisdom can say, look, we are seeing disparities, these are historic disparities, we have to treat unequals unequally. This is criminal law. You cannot tell me that the severity of exactly the same action changes based on identity of an individual. That's not fairness.
Nikhil Mehra, we'll have a longer conversation on freedom of speech very soon, but for today, we'll have to leave it at that. Thank you very much for explaining this. And I think, as you know, there's almost every decade goes by and younger people, come online. They have no recollection and they have no knowledge that all of this happened, even though it happened only 10, 15 years
I'm
ago.
sure you know this quote. I'm sure you'll know who said this. But I believe the quote was something to the effect of a lot of writing that every generation has to do is the preservation of memory.
Absolutely. Absolutely. No, let me tell you, I mean, when I wrote my Patel book, I was shocked how in Ahmedabad, young people knew nothing about Sardar Patel. In Ahmedabad, Nikhil, not in Calcutta, not in Chennai,
And you know
in
what gets
Ahmedabad.
worse? What gets worse is when a certain time, in a certain place, that kind of knowledge is commonplace.
Yes.
It's everyday knowledge and it
Yes.
dissipates like this.
Yes. No, absolutely. And that's for all the more important to, examine issues like this, because like you said, the politics continues and this might well happen again tomorrow.
Or
Uh,
it may take another form.
yeah,
So
it may take another form. Thank you, Nikhil. Thanks very much
thank you so
for a
much.
wonderful explanation, very detailed, very nuanced. Thanks very much for your time.
Thank you.